A new twist in a long-running criminal case involving a former San Leandro police officer. He stands accused of shooting and killing a man inside a Walmart. But now the Alameda County District Attorney is filing a motion to dismiss the manslaughter case. It's a move that does not sit well with the family of Stephen Taylor. They've been waiting years to see this case go to trial. John Ramos reports on what they consider a denial of justice.
It was in April of 2020 that Stephen Taylor entered this Walmart in San Leandro. Police were called when he was suspected of shoplifting, and when former officer Jason Fletcher arrived, Taylor was holding a baseball bat. In the next 40 seconds, Fletcher tased him twice and then shot him in the chest, killing him.
I don't think I'll ever be able to move on. I'll never forget. How do you forget? How do you forget?
To many in the community, the killing felt rushed and unnecessary, and then DA Nancy O'Malley filed charges against Officer Fletcher. It wasn't something she was accustomed to doing.
Before that point, during her entire career, she had never, not one time, charged or prosecuted a single solitary cop for murder. Not once. He was the first one.
On this day, a group of protesters, including Taylor's grandmother, Addie Kitchen, gathered at the Alameda County Courthouse because after 5 years, 3 DAs, and the sitting judge, Thomas Reardon, twice refusing to dismiss the case, current District Attorney Ursula Jones Dixon has told the family that she intends to drop the charges against Fletcher. And the motion to dismiss is scheduled to happen on Friday when Judge Reardon is away on vacation.
I don't know how we got here. 5 years, 6 months. How many people have touched this case? Judge Reardon saw fit to not dismiss this case twice. And here comes the district attorney who says reasonable doubt that she didn't feel she could win this case.
Shannon Dugan is a KPIX legal analyst and former DA. She says the optics of dismissing the case when the judge is gone may be bad and may anger the family, but she says it is the district attorney's power and perhaps responsibility to drop the charges if she doesn't think she can prove them beyond a reasonable doubt.
The judge does not have the power to force the DA to proceed with the case if the DA decides to dismiss the case. What I was taught when I was a DA, and what is still the duty of the DA, is if you don't think you can file a case beyond a reasonable doubt, you really shouldn't file it.
The DA's office refused to comment on the active case today, but the family says in the conversation they had on Tuesday, Jones Dixon says she was concerned that the case was too old and there may be problems with witnesses and expert testimony. But Addie Kitchen thinks there may be another reason.
She does not want to charge a policeman, period. That's her reasoning. She does not want to charge a policeman. She's already dismissed cases on officers.
The motion to dismiss charges is expected to be filed on Friday afternoon in Alameda Superior Court.
So as John mentioned, we reached out to the DA's office and we had specific questions about the decision to dismiss the case while the presiding judge is on vacation, and also find out why they wouldn't let a jury decide this case. A spokesperson for Ursula Jones Dixon said the office could not comment on an active pending case.